Suppose you are in a market. You want to buy something. You give the shopkeeper the price of that item, and the shopkeeper gives you the specific item. This is the simplest form of contract. The basic idea of contract depends upon buying something and selling something. Until and unless you come to know there are different kinds of contract in law. Hello, I am a law student, and today in this video I shall discuss with you what are the different kinds of contract in the Indian law. To form a valid contract, you need an agreement, and the agreement must be enforceable. So you can say agreement plus enforceability is equals to contract. This is what section 2H of the Indian Contract Act says about a valid contract. The first thing to form an agreement or a contract is the willingness of the party, the intention of the party to buy something or to sell something. And then comes the consideration. For the buyer, it is the book. For the seller, it is the money. When we have this promise plus consideration, congratulations, you have made an agreement. But the thing is that the agreement must be enforceable. Enforceable by the court of law. Now the question is what makes an agreement enforceable by the court of law? It is in section 10 of the Contract Act. Simply, it is the parties who are making this agreement must be competent enough to make that agreement. Both parties must have free will to enter into that agreement. The object of the agreement and the consideration also must be lawful, and also the law must permit it. Suppose your state government says that you cannot sell here liquor or alcohol. Then you cannot do a contract with a person that give me money, I will be selling here alcohol. It is not valid because it is barred by law. These are the essentials of a valid contract to understand what are the kinds of contract in the Indian law. Because valid contract is itself a kind of contract. We have other types of contract like void contract, voidable contract. After going through the interpretation clauses of the Contract Act, I have come up with this idea of understanding the types of contract in a mathematical way. We have already learned that when agreement is enforceable, that means agreement plus enforceability makes a valid contract. But when a valid contract ceases to be enforceable by law, it becomes a void contract. So valid contract minus enforceability is equals to void contract. You must remember the 5 points of enforceability that we have talked about. Competent parties, free will, lawful object and consideration, and not void by law. If one party proves that he did not have free will, then the contract will be unenforceable for that option of one party. So, a contract lacking enforceability from one party makes it a voidable contract. I can give you a shortcut trick to understand it. Just see the word voidable. The last word is able. Able comes from ability. So one party is having the ability to make it unenforceable, to make it lacking enforceability from one party. If it is lacking enforceability from one party, then it will be a voidable contract. Void ab initio, the next type of contract. It means void from the initiation, from the very beginning when a contract is void. For example, if you do a contract with a minor about something, it will be void from the very beginning, making it a void ab initio contract. You can say it is a part of void contract. In a quasi contract, what happens that it is not a contract which has all the ingredients of it. It is a contract like relationship, a relationship obligation which is like contract, not exactly contract. Suppose if I see a minor person who is not able to support himself, and then I give him my support by providing him necessity of food, money, education, clothing, whatever. Then the person who is taking all kinds of benefit has an obligation towards me to reimburse or repay me later on. If he does not do so, I have a right to get that repayment, reimbursement from the estate property of that minor. This is a type of quasi contract. Quasi contracts are mentioned in 68, 69, 70, 71, and 72 of the Contract Act. Further, we have two kinds of contracts: express contract and implied contract. In an express contract, the terms and conditions are expressly defined. It may be either orally or in a written format. But on the other hand, in an implied contract, the terms and conditions are not expressly defined. It is implied by the conduct of the parties. The next type is unenforceable contract, which is in the proviso of the section 10 of Contract Act. To make it simple, understand it like this way. If you and I have a contract and the law says that we need to register it, we need to sign it and make it in pen and paper mode. That means duly execute and duly register it. Then there is no way otherwise than to register it. For example, if I want to give you my 100 acres of land in lease for 100 years to you, then we have no other way than to register it, to duly execute it in the way the law is saying us to do it. If we fail to perform, it will be an unenforceable contract. Do you remember the very first example we had taken? The shopkeeper gives you the book and you pay the money for it. It is a type of executed contract, which is also known as present contract. The giving and taking is done in the present format at the present time. But it is not in the case of executory contract. In an executory contract, it becomes a future type of contract. When one party gives you something, the shopkeeper gives you the book, but you say that I shall pay for the book after 2 days. So it becomes a executory types of contract when one party does his part, performs his part in future. Now understand what happens in an ordinary contract. When two people come at a point, they makes a contract with themselves and they set the terms and conditions of the contract according to their own comfort, according to their own will. So basically, in an ordinary contract, the terms and conditions changes according to the parties. But on the other hand, in standard forum contract, there are fixed terms and conditions in a contract. Suppose you are going to book a railway ticket. The railway company has already given you a format. You need to put your credentials there. You cannot bargain. The terms and conditions are fixed. Again, when you make any insurance, you cannot introduce your own terms and conditions. They are fixed. There is a specific format. The last two types of contract in this series are contingent contract and frustrated contract. A contingent contract is basically based upon a future uncertain event happening or non happening of it. Suppose I say, if there is storm today, then we shall make a deal. Our deal is to buy and sell a TV, but it is based upon a future uncertain event. No one can say that today we will be definitely having a storm or rainfall. You see how uncertain it is. Now listen very minutely what a frustrated contract is. If to be a frustrated contract, we must have a valid contract at the very beginning of happening of a certain event. Rainfall is an uncertain event, but a football match, if the date is declared, place is declared, time is declared by the authority, then it becomes a certain event. But if all the players from the both team get sick unwell, then the football match do not happen. Then the football match does not happen. Who will play? The players are all sick. I again repeat, the football match was certain. The happening of the full football match was certain. But somehow there becomes an accident which makes it impossible. So the contract initially was a valid contract. The impossibility comes later on. The accident happens later on, which makes the audience frustrated, and there is frustrated contract. Jokes apart, here doctrine of frustration is applied. What is doctrine of frustration? We shall understand it in later on videos. If you are here with me till now, I have a bonus for your attention. Students easily gets confused in contingent contract and frustrated contract. Here I shall try to make it clear. I shall take on the best possible example in my mind. If I just randomly tell you that 10 days later, if there is a storm, if a storm comes, then we shall have a deal. I shall sell you a very nice TV and you accept it. So we are on the point which is uncertain event. It is uncertain from the very beginning. Or suppose we are sitting under a mango tree. If I say that if in 1 hour a mango falls down on the ground, then we shall have a contract of I shall sell you a TV and you shall buy it and you accept. So we have a contract on an uncertain event. Our point is falling down of a mango from a tree. This is so uncertain an event. Now listen what happens in a frustrated contract. We have a certain event. Suppose our Prime Minister is having a victory rally in our hometown, and the road which is declared that in this road there will be a rally. The road is just beside my house. From my house, you can see the Prime Minister. So you take the balcony of my house for that specific day, for that specific time, for 4 or 5 hours, only to enjoy that rally, which is specific one. The date, time, place is declared already. But unfortunately, on that day, we have a war-like situation, and on that day, the Prime Minister cancels that road rally because he has a larger duty to perform. Like you come to my house on that day, and unfortunately, all of a sudden, you get informed that the rally is cancelled. We are at a shock. So, 1 month before, when we had our contract of renting that balcony for that 4 or 5 hours, it was a valid contract with all the essentials and ingredients in it. But later, today only, this unfortunate event happened for which our contract got cancelled. It gets frustrated. So, this is the basic difference of a contingent contract and a frustrated contract. And now I hope my explanations are worth watching, and thank you for your time and attention. Please subscribe to my channel for such informative video and good explanations. And comment whatever point you liked. Just leave a mark in this video. Like this video and subscribe to my channel. Thank you again.